This is Juliana too, and thank you for watching. This is my escrow tip number 14. Purchase contract versus escrow instructions. What is the difference between these two? We had a big national lender who was doing a loan for our buyer in a for sale by owner transaction. This was a finalization of a lease with option to buy contract, and there were no real estate agents involved. The buyer was the tenant, the seller was the landlord, and they agreed to open escrow based on that lease contract from years ago. As the escrow holder, I drew up my escrow instructions, which finalized the terms between them. The escrow instructions state that one party would sell and the other would buy the specific property within a specific time period at a certain price and subject to certain conditions. In effect, a purchase contract. Well, this big national lender couldn't get past the fact that because there was no real estate agent involved, there was no realtor-driven purchase agreement form, and so they could not check off that box on their list to finalizing the loan. Okay, there might not have been an actual document named purchase contract to show the agreement between the parties, but what did they think my escrow instructions were, if not the agreement? They refused to accept my escrow instructions as the purchase contract between the parties. This is their response 2 months into the transaction and 1 week before closing. My underwriter states that we are not able to accept this escrow instructions as a purchase contract because the document is not labeled as a purchase contract. Can you go back to the buyer to see if they have a document that is actually called a purchase contract and not escrow instructions? If they don't, the buyer may have to download a purchase contract from the internet and complete a new document that is labeled a purchase contract. Now that totally threw me. What do they think that I, as a settlement agent, do? What do they think we draw our escrow instructions for if it is not to memorialize the purchase and sale agreement conditions between parties? They want my clients to go search the internet and find a purchase contract form from any website, download it and sign it? Do they understand that once my clients sign this internet found form, it becomes a legal contract that can be subject to a court of law in the event of a dispute? Seriously? In effect, this lender, for their underwriting condition, is asking my clients to throw something together and label it purchase contract as the heading instead of using my instructions, which were formulated and tailored to their transaction specifications and includes required regulatory guidelines and overviewed by my legal counsel. So here is my escrow tip, and this is one that is not just for the general public, but specifically for lenders, underwriters, and processors. If you know of any, please refer them to this video. The escrow instructions is the main contract signed by parties to memorialize their agreement to buy and sell. It is a purchase contract, although under another document name. Renaming my escrow instructions to purchase contract does not change the nature of my document. Making such a requirement to get a loan approved shows that there are huge underlying issues in the system. Do not put your clients, my buyer and my seller, into the position of trying to fulfill conditions that make no sense. Learn what the function of the settlement agent escrow holder is. If you don't learn, you will come across sounding at the best inexperienced and at the worst embarrassingly uneducated. It reflects on you, your company, and your industry. And to think that these are the professionals who are making decisions on the lending of billions of dollars every year. This is Juliana too, and I stand for the escrow establishment, which often has to work with incomprehensible demands put on us. Thank you for watching.